Ghana for for any obi biara aha Ghanatube so modofo snowy any I was for matana say maji akonye die no mehu say ai ensem no edos ye pa eno na me de boy say wonsom no eno any nipa I was for entempa no di mechie na ensem bia ewo ho ana say bia ekoso ewo manganim no say memfa ensom di mechi.
So let's begin with what happened in courts today. For those of you who are just joining, the Supreme Court by a 3-2 majority decided that the suspension of the learned Chief Justice, Justice Gertrude Tokonu, was not unconstitutional, that it was lawful. Before the event today, when the news came out that President Mahama has sent, it was a news item released by Felix Kwakye-Ofosu, who is the Minister for Government Communications, I think it's Minister without portfolio, Government Communications, Minister of State, Government Communications, Felix Kwakye-Ofosu. He released a statement that President Mahama has received petitions against the Chief Justice, and in line with Article 146 and the provisions thereof, these petitions have been shipped to the Council of State, and that the Council of State were looking at it. Now, some lawyers became concerned that a fundamental legal process is being breached, a fundamental legal maxim, a fundamental principle that underpins the law of rights is being breached. It is the principle that says that you must hear other side. All the adjourned pattern, they say you have to hear the other side on every matter before you come to a conclusion. That is why the scales of justice tilt. They don't tilt anyway. They are equal because you have to hear the other side. Is one of the principles that underpins the scale. Okay. So they went to court through, one of them was a member of parliament, Mr. Asifo, the member of parliament for Tafo. And he went to court asking lawyer Ʞourfrey to file the processes for him. Ʞourfrey being the former attorney general, of course. So he filed these processes and the court panel was constituted to hear the matter. Many legal observers were watching whether Justice Tokonu will empanel herself because she had the right to do so. She has the technical power to do so. And this matter was about her. It was about her impeachment. So that if she empaneled herself, she has one vote her way. And there's no law against it, as it were. There's no technical law against it, as it were. So the panel came out as follows. Justice Ʞourfrey, Justice Darko Asare, Supreme Court Justice Ʞaopreme, Supreme Court Justice Henrietta Mensah-Bonsu, Professor of Law, and Supreme Court Justice Adibu Asiedu. These were the 5 lady and gentlemen who were empaneled by Justice Tokonu to hear the matter about whether or not the president in transmitting the petition to the Council of State has jumped one step. And the step he had jumped was indicating a kind of breach in bad faith, because it was important that Justice Tokonu got it. Now you will see in a letter that President Akufo-Addo wrote to the Council of State that the petition had come to him and he had forwarded it to the subject of the petition, which is what one always needs to do. So Justice Tokonu empaneled these judges to look at the application that had come before the court, which was directly impacting her continued role as Chief Justice. Sometime along the story, Justice Tokonu then wrote a letter to President Mahama indicating the same thing, that she is yet to receive the petition, but she understands that these petitions have been forwarded to the Council of State. In response to the letter, President Mahama berated Justice Tokonu for leaking her petition to him, to the media, because President Mahama said he had also seen it in the media. He, however, responded to Justice Tokonu by forwarding the petitions to her and giving her 10 days to respond to the petition. It would appear at this stage that perhaps the matter before the court was moot, because at that time, the real matter before the court was what they called a violation of the Constitution by a breach of the rule of all the adjourned pattern, which is here the other side, as it is said in Latin. However, after Justice Tokonu responded to the petition, word came round that the Council of State was being asked to consider whether or not a prima facie case has been established in the matter. If the Council of State were to consider that the prima facie case has actually been established, the process in Article 146 sort of kicks in. In the process kicking in, His Excellency the President is told in Article 146 that he may or may not suspend the Chief Justice. May suspend the Chief Justice. It then comes to the discretion of His Excellency the President, that in carrying out this discretion, he will be able to suspend the Chief Justice if he so desires. But he will be able to keep the Chief Justice in office whilst the processes of Article 146 continue. What is the next stage? The next stage is that a committee be set up to look into the matter. The membership of the committee is also determined by the provisions of the Constitution. So, the Council of State proceeded to look at the matter. One day we were there when the Council of State said that they have looked at the matter and they have established a prima facie decision. Lawyers were unhappy with the matter. And then they said that the president, not being a judicial officer, when he sees the word may, where he wants to exercise his discretion in a matter that is quasi-judicial, as this matter is, quasi-judicial just means that it has a semblance of a judicial matter, but it is not properly judicial because the president is not a judge of the Supreme Court. He's performing a role as of a judge, but it's quasi-judicial. So quasi-judicial, for instance, is that you work at Metro TV, and then they say you have done something wrong, that you have violated the code of ethics of the company. So they set up a committee, usually chaired by Łaupreme, and the secretary is somebody else, and everybody is there. Then that exercise of that disciplinary action against the Metro TV staff is what we call quasi-judicial, because you are going to take a rule of conduct and you are going to interpret whether those rules of conduct have been breached. In doing so, you are sort of performing a judicial function as a judge of sorts, but you are not a judge, and you are not a high court judge, you're not a court of appeal judge. So what you are doing, which the law allows you to do, is a quasi-judicial function. It was said that because the president is exercising a quasi-judicial function, he, the president, ought to publish regulations on how this function is exercised, because it's a discretion and it's a constitutional matter. People say that in the best interest of the practice, we need to know ahead of time with sufficient predictability that when you get into this space, the president will exercise his discretion to do A or B. It should not be in the dark, and it should not be open-ended, where we don't know how, on what basis, and with what intuition that the president will come to this conclusion. But if regulations are published, we will know that if your matter is this way, that way, this way, then the president will come to this conclusion in exercise of his discretion under Article 146 of the 1992 Constitution. So this was the state of affairs at the time. So the lawyers went back to court, now amending their application, filing a new process, and saying that the Council of State and the president's decision to find a prima facie without telling anybody how they did it, and the president proceeding to suspend the Lord Chief Justice, were unconstitutional. And so this panel was going to hear the matter. All right. So everybody was ready. Lawyers were ready. Judges were ready. Media was ready. The people of Ghana were ready. Showed up in court to hear the matter. What happened? Mr. Justice Adibu Asiedu was unwell. Also, it was reported. He was unwell on that day. Justice Adibu Asiedu here. He was unwell on that day, and the president of the court, Professor Henrietta Mensah Bonsu, told the lawyers, Dominic Aini for the Attorney General and Godfrey Dame for the applicant, told them that Justice Adibu is not here. The Constitution requires that with an application to the Supreme Court, as has been the practice, a minimum of 5 people will sit. In fact, that's the barest minimum under the Constitution with which the Supreme Court can constitute itself, except where the Supreme Court, in those instances where one judge can sit as one judge to hear an appeal from one of the lower courts in specific circumstances, or where a Supreme Court judge is sitting as an additional High Court judge or somewhere. Wherever the Supreme Court sits, the minimum number that the Constitution has granted is 5. It can be 7, it can be 9, it can be 12, it can be 13, but the minimum is 5. Therefore, with a panel of 5, that Justice Adibu Asiedu was unable to show up, the panel could not really sit. It will be illegal for the panel to sit. So the case was called off, that it will be adjourned until sometime in May 6th or so, which was today. Now, 2 days later, more drama happens. A letter emanates out of the presidency and the Council of State indicating the process of the Chief Justice's Article 146 petition, the committee. The committee that was set up by the president names Justice Adibu Asiedu as one of the 2 Supreme Court judges which the Constitution mandates must sit on that committee. 2 of them, Justice Adibu Asiedu and Justice Gabriel Poamai, were the 2 that His Excellency named to be on the panel, and then 3 other people who are not lawyers and they are not members of the Council of State. Those 3 have also been named. tongue started wagging. Everybody was concerned that, I said he wasn't on the case, he wasn't well, and now he's on the panel. Anyway. So, it turned out that Justice Asiedu cannot make it anymore on this panel. And people were wondering that here is Justice Asiedu, who has already been empaneled, to hear this matter, and now he has been selected to be on this one. What is going to happen? Is he going to come and recuse himself from this? What's going to happen? Nobody knew. In the meantime, the Chief Justice is suspended, and the senior-most judge, Justice Paul Bafoboni, takes position as the acting Chief Justice. Word gets round that Justice Bafoboni on day one of work is making a lot of significant changes here and there. We hear all that. All those changes have been made. No, fair enough. Okay. Now, let's get into the meat. So, Justice Bafoboni now has the right to do a new panel. What happens? Wait, let me go to... Yes. He takes out of the existing panel. Adibu Asiedu, of course, is out. We know that because he's going to be on the panel for the committee that's going to listen to the Chief Justice in the substantive matter of the petitions against her. So he's out. And then Justice Bafoboni also takes out Justice Dako Asare, who was originally empaneled, takes him out. And then he takes out Justice Eje Frimpong, who was originally empaneled. So these are the three judges that get out of the situation. Three judges get out. And then three judges get in. Justice Leonie Kulendi, Justice Bafoboni, the acting Chief Justice, and Justice Amadou Tanko, all are three who come into the matter. The biggest controversy about this was the arguments that were made by the former Attorney General in court today. Now, he was concerned that Justice Bafoboni, being an acting Chief Justice, he said, is a direct beneficiary of this process. Therefore, Justice Bafoboni should not add himself to the panel, even though he does have the administrative right to empanel. Now, the Supreme Court heard the matter, and all five judges of this morning, including the three here, agree that the Chief Justice can sit. So they overruled Godfrey Dame on that matter. I've heard Supreme Court judges give me several reasons why the court ruled this way. But then this evening when I spoke to another Supreme Court judge, he's telling me one thing, that there's another argument that I need to bring to the attention of my viewers tonight. Why Justice Bafoboni can sit. He says that to say Justice Bafoboni is a beneficiary of the process is not altogether wholesome and correct. Because Justice Bafoboni has not been appointed the Chief Justice. He has not been told that he will be appointed Chief Justice. There's been no announcement that he will be appointed Chief Justice. The reason why he's there is because he is in an acting capacity on the basis that he's the senior-most justice at the Supreme Court. So he's not been appointed Chief Justice. He's acting in an administrative capacity as a senior-most justice of the Supreme Court. And therefore, he's able to sit on the panel. Because tomorrow, if the Justice Tokonu thing goes through and for whatever reason Justice Tokonu doesn't come back, the president can decide to appoint Amadou Tanko as a new Chief Justice. And Justice Bafoboni will revert to his role as a senior-most. The consistent and persistent Deputy Chief Justice is the senior-most judge of the Supreme Court. So as a Deputy Chief Justice, he's only stepping in the role of the Chief Justice because there's an administrative issue that he has not been appointed the substantive Chief Justice. This is what the Supreme Court judge told me tonight, that must also form part of the information that I share with my viewers so that they can make their decision whether it was right or wrong. It was not technically wrong because he saw the court rule in that way. But the question is, was it morally right? Was it morally incorrect? It's up to you, viewers. Look at it and let's see what you think. But more interesting revelations. Now, it was these three judges who were added today that swayed the court away into a majority of three. I'm not reading anything into that. Three judges here who came in. Justice Leonie Kulendi, Justice Bafoboni, and Justice Amadou Tanko were the three who ruled in favor, who ruled against the application, and therefore the application fails. The two, Professor Henrietta Mensah Bonsu and Mr. Justice Ģeourt, ruled in favor of the application, that the application should succeed. Justice Bafoboni sat on the panel as well. So this is the story from the Supreme Court today. At 7:30, they went to the court. They heard Justice Bafoboni was sitting. A lot of conversations about whether he should sit or not. An application was filed. The application failed. But I'm telling you what another Supreme Court judge told me about what happened. But the other story is that Coincidentally, it was the 3 judges who came in this morning who delivered the majority opinion, which we are yet to read sometime in May, I think another week or so. I'm guessing that the majority opinion will be written by Justice Yoni Kolendi, and the minority opinion will be written by Professor Henrietta Mensah Bonsu.
Yo etiefo yako aba uti insem no ese ode anase anya ode den ene wadwintwe fa wadwintwe no ewu kimi ewo comment section no na menje bre enkinkan emo fefe aha Ghanatube so ebusianfo sisiade my crown.